वाक्य देखा है वो? हाँ? तो बोल बदल दे, तो एडिटिंग बदल बोल दो, ना बोल एडिटिंग करें। Welcome to Vanik YouTube classes. This class will discuss certain important questions based on salient features of Indian Constitution. Salient features of Indian Constitution is very important part chapter in Indian polity and governance. It covers almost all parts of the Constitution briefly, right? So we need to focus on the areas, and I have chosen some very important questions for on this chapter, which will be useful for your upcoming examinations. Indeed, salient features. In the salient feature chapter, we discuss more than 17, 18 points related to Indian Constitution, like lengthiest nature of Indian Constitution, drawn from different sources, which is a vital part of the things. What are the sources of the constitutions? What are the major provisions that are borrowed from different successful constitutions in the world? Indian Constitution has borrowed some of its important provisions from different constitutions like the USA, those of USA, France, UK, Australia, Japan, South Africa, Russian Constitution, French Constitution, and so on. We have largely borrowed the pattern from British Constitution, no doubt, but there are certain provisions which have been borrowed from other constitutions that I have told you. And there is also certain aspects of Indian Constitution which is taught in this chapter, like blending of rigidity and flexibility. Indian Constitution is a blending of rigidity and flexibility related to amendment. And India is an example of that is a synthesis between parliamentary sovereignty of the UK and judicial supremacy of the USA. Then there are federal in form, unitary in spirit that we also discuss, and there are fundamental rights, DPSPs, fundamental duties, and your quasi-federal nature of the things. All these things are noted here. Okay, so I have chosen some selective questions for this chapter. Okay, kindly read the chapter well because very important chapter. So we start the questions. Look at the questions. Number one, in the context of India, which of the following principles are implied institutionally in parliamentary government? Institutional means what are the provisions that are found in Indian parliamentary system? That is, members of cabinet or members of parliament, obviously, because the ministers in the council of ministers, cabinet is a part of the council. There are three types of ministers usually. One is your cabinet minister, minister of state, and deputy ministers. All are members of parliament. That is also called the dual membership of the executive. Dual membership of the executive means the executive. Who is the executive? The council of minister and the prime minister. They are the executive and they are the member of parliament because this is the requirement of parliamentary democracy. So that is why members of cabinet is considered are also the members of parliament. That is correct. They must be member, although they can be appointed without being a member, but they have to secure a seat within 6 months from their appointment, from the date of their appointment, and become a member of parliament, compulsory. That is an essential provision. Okay, so it is correct. Ministers hold office till they enjoy confidence of the parliament. Is that is collective responsibility. So under Article 75, Clause 3, 75 Clause 3, you will find collective responsibility of the Council of Ministers headed by the Prime Minister. So that is also correct. And cabinet is headed by the head of the government. That is the Prime Minister, not the head of the state. So it is head of government, Prime Minister. President is not the head of the cabinet, rather the Prime Minister. So that is wrong statement. And it is correct because it is mentioned in 75 clause 3, collective responsibility. So answer will be 1 and 2 only, A. Is it clear? So now we'll come to the second question. बात देखेंगे 2 नंबर क्वेश्चन. Which one of the following is not a feature of Indian federalism? See, Indian federalism is a typical federalism. We are holding together federal countries. We are a holding together federation. America is a coming together federation. We are a holding together federation. And in this federation, there is some provisions are lacking. Like there is no agreement between the states and the federating government. And there are certain things. So holding together is naturally is not classical federation. We are not purely a federal country. Considering the security of the country and unity and integrity of the nation, we have given certain powers to the union government, some unchallenging power. So we have a quasi-federal system, semi-federation. So there are certain provisions are lacking. Look at the first point. There is an independent judiciary in India, yes, and it is also required in a federation. Powers have been clearly divided between the central and state, yes. The federating units have given unequal representation is correct. The federating units have been given unequal representation, yes, correct. In a typical federation or in a coming together federation, the states are given equal representation in the upper house, because Rajya Sabha, there must be a upper house in a federation. For example, in America, the upper house is known as Senate, and in Senate you will find equal representation of state, irrespective of their size, geographical and population size. But in Rajya Sabha, that is the upper chamber of Indian Parliament, you will find unequal representation, because the representation in the Rajya Sabha is provided on the basis of population. So that is a unitary provision. That is not a federal provision. So that is also correct. It is the result of an agreement? No. Therefore, we are called a holding together federation. Therefore, we are called a holding together federation because there is no agreement among the federating units. We have implanted federal government considering the huge size of the nation. Because in a country of India's size, in terms of population and geography, it is not possible to have a single government. Unitary government is not feasible. Therefore, we need a federal government. We need to decentralize some powers to the states. Therefore, the Constitution in the 7th schedule provides a division of power between the central and states and grants autonomy to the states in regional matters to a great extent. So therefore, unlike American Constitution, we are not, our federation is not a product of an agreement among the states. So answer will be D. Question number 2, answer will be D. Getting it? Now consider what is true of a republic. Republic is a term which is borrowed from French Constitution. French. Republic means where the states are, head of the state is elected, not hereditary, and people elect their representatives and to rule themselves. So if you look at the options provided here, you will see first one is correct, second one is correct. So obviously third one is not correct because the head of the state is not hereditary in nature. So answer will be C, 1 and 2. Republic is borrowed from French Constitution. Kindly get an idea of French Constitution. Okay, number three is C. Next, number four. The Indian constitution closely follows the constitutional system of UK that I have already told you. We have provided parliamentary government. So parliamentary government is found in mostly that we have borrowed it because we have been ruled by the British government for hundreds of years, more than hundreds of years. So we have learned the basics of parliamentary system. Therefore, we felt comfortable. And there was other reasons also because the nature of Indian population and the composition of population and the vastness of the country require parliamentary government in place of presidential government. So there are certain compelling reasons why the makers of the constitution have accepted or adopted parliamentary system. That is the reason, but it is followed. But remember, the parliamentary government provided in the UK is not the closely similar or almost all the provisions of the parliamentary systems are not similar to that of India. There are certain differences between UK parliamentary system and British Indian parliamentary system. There are a lot of things. For example, most prominent difference is that the parliament in India in the UK is quite sovereign. Therefore, it is called ki parliamentary sovereignty prevails in UK. But in Indian parliament, in India, parliament is not as sovereign as the UK parliament. There are certain factors which limit the power of Indian parliament which are not present in the UK. For example, written nature of constitution, division of power, judicial review, fundamental rights. There are certain factors which limit the sovereignty of parliament. Therefore, British Parliament is not, Indian Parliament is not as sovereign as British Parliament, but we have to say that it closely follows the constitutional system because there are a lot of similarities between them. So, answer is A. Which of the following mainly determine the constitutional system is federal? Mainly determines. See, there are all the provisions that are mentioned are federal provisions. If we see all the provisions like written and rigid constitution, that is also required. Written and rigid constitution, we are partly distribution of power. Distribution of power between the central and states is the main things that determine that Indian constitutional system is better. Because the written and rigid constitution may be there, independent judiciary may be in a unitary position also there. Okay, so best option is B because most important component of your what of your federation is distribution. Distribution the main provision ରହୁଛି distribution ଟା ରହିଲେ ହିଁ এটা ହବ ସେଥିପାଇଁ all these things are necessary. Okay, so this is all about your question number 4 B. Now I'll come to question number 6. The word secular found enshrined in the preamble to the Constitution of India means. Let us see the questions. Let us see the questions. The options provided here, visible here. The state protects all religions equally. Yes, that is the fundamental thing of a secular country. All religions have equal status. All religions have equal status. That is to be there also. Okay. of equal status. Okay. Then state does not uphold any religion as the state religion. Yes, there is no state religions. And major things is that the state does not patronize or provide patronage to any religion. Okay, that is also a point to be noted. Freedom of faith and worship is allowed to all people. Yes, under Article 25 to 28. Freedom of religion is provided. So under Article 25, freedom of conscience, freedom of profession, freedom of profession, practice, and propagation of religion is provided. So that is also correct. So three options, three statements are correct. And therefore, we have to move to the fourth option, if any. Fourth option is there. State makes no discrimination on the basis of religion in matters of employment. Yes, that is provided in Article 16. 16 रे ଅଛି जे no person shall be discriminated in matters of public employment on the ground of religion, race, caste, sex, place of birth, and so on. So all the options, as you can see, are correct with regards to Indian secularism, which is quite positive in nature. Okay, so one, two, three, four are correct. That is there. The Indian Constitution is regarded as unitary, federal, parliamentary, federal in form, unitary in spirit, जो हम quasi federal कही So that is Casey Hoyer made this statement. It is a quasi federal system. So we have both federal and unitary provisions. As I told you, unitary nature because control in the hand of central government is essential for certain factors. National decisions at national level is required. For this reason, the constitution makers did not provide for classical federal system in the country in pattern in line with American system. Rather, they preferred mixture of both federation and unitary government. There are certain compelling reasons for that. It when Casey Ware has rightly described India as a federal in form, unitary in spirit. Okay, so answer is D, 7. Number 8. Which of the following features of Indian Constitution does not resemble the American Constitution? Doesn't resemble the American Constitution. We have a written Constitution, they have a written Constitution. We have fundamental rights, they have fundamental rights. We have federal government, they have federal government. But we have an appointed governor, but they don't have appointed governor. They have elected governor. So under Article 155, the governor of India is governor of a state is appointed by the president. That pattern we have borrowed from the Canadian constitutions. So we have not borrowed it from American constitution. So unlike America, our governors are appointed by the central government or by the president. So answer will be D. That is the doesn't resemble both. Okay. Look at question number 8. Which is a feature of parliamentary form of government in India? Dissolution of upper house? No. Upper house in the parliamentary system is not dissolved. Is not dissolved. Rajya Sabha is not subject to dissolution. It is a permanent house. Leadership of the Prime Minister is correct. President is the head of the government. Full Prime Minister is the head of the government. Separation of power is there, but we don't have strict separation of power. Rather, that is you called executive and legislature are the member are close together. So we have doctrines of checks and balance in place of doctrines of checks and balance. Acceptance of checks and balance. So answer will be your B. B is the best answer. Now we'll come to question number 10. The system of dual head in India is the replica of dual head means the head of the government and head of the state. So we have borrowed it from Britain. But there is a difference also. Although there is a difference, but we have the similar pattern, two heads. But in Britain, the head of the state is hereditary in nature, but in India it is elected. That is another part of the things. So answer will be B. The concept of question number 11, the concept of federation with strong center derived from Canada, so quasi-federal system. So answer is D. Which article contains the reservation of SC and ST in the Lok Sabha legislative assemblies? Out of these articles, you will find 334 because the such reservation can be extended by periodically by Parliament. But remember, Article 330 deals with reservation in Lok Sabha, and 332 individually deals with reservation in the legislative assemblies of the state. Question number 12 is answer B. Okay. Question number 13. Which of the following is not correct? There were 22 parts in the when it was adopted. Yes. There was originally 8 schedules. Yes. 395 articles when the constitution was adopted. Yes. Originally the constitution did not contain a preamble. That is a wrong statement. It had the preamble. Question number 14. Which among the following features is not borrowed from USA? We have borrowed impeachment of the president from USA, election post of vice president also, removal of judges of Supreme Court also. So this provision was borrowed from Irish constitution, election method of election, proportional representation by means of single transferable vote, that we have borrowed from Irish constitution. So answer will be C. Post of VP is mentioned in Article 63. Impeachment of this provision is 61. Removal of judges of Supreme Court is mentioned under various articles 124 to 17 and other also an act is provided for that. So that will be C. So 14 is C. And then article question number 15. Which of the following is not a federal feature in Indian Constitution? Independence of judiciary is a federal provisions. Distribution of power is there. Single constitutional citizenship is not a feature of federation. Rather, it is the feature of the unitary government. But India has single citizenship, so we are not a purely federation country. That is D. Match the following sources and contents. Look at the contents. Fundamental rights, directive principle of state policy, bicameralism, and fundamental duties. Fundamental rights are borrowed from USA. Defense fee has been borrowed from Ireland. Bicameralism has been borrowed from UK. Fundamental duties from USA. So we have answer 1, 3, 2, 4. We have answer 1, 3, 2, 4. Okay, answer is C. We'll now come to question number 17. 17 is the answer. 17. Nomination of members nomination of members, which is correctly matched. Nomination of members of Rajya Sabha is borrowed from South Africa. It is incorrect because nomination of members of Rajya Sabha under Article 80, which is provided, is borrowed from your Irish constitution. Election of members of Rajya Sabha is borrowed from South African constitution. Office of the governor is from Government of India Act 1935. The concept of republic is from France. So only D is correct. The basic questions we are discussing. Okay, then we will come to the higher level that in the upcoming classes. Okay. So procedure established by law. Procedure established by law is mentioned in Article 21 only. No person can be deprived. The article, what does Article 21 says? 21 says that no person shall be deprived of his or her life and personal liberty except procedure established by law. So this is the principle on which the judicial review is carried on by the courts. So procedure established by law is the basis of judicial review in India. It is the basis because in America there is due process of law. So in case of India, the laws will be reviewed by laws enacted by Parliament or the orders issued by the executive shall be reviewed by the Supreme Court and the High Court within the parameters of law. They cannot provide overt interpretation of law. They cannot establish whether law is just, fair, and reasonable. So that is a extra interpretation of law. But in America, it is there, due process of law. But in most cases, Indian judiciary has adopted due process of law. For example, in Menaka Gandhi versus State of Union of India 1978 case, Article 21 was overtly interpreted, and it said that the right to life also includes right to life with dignity and right to travel abroad. So many inferred rights have been brought under Article 21 by the process of due process of law. Okay, so that is, but this is the fundamental principle 21. 19. Question number 19. Which among the following is incorrectly matched? Independent judiciary, USA, right. Advisory jurisdiction, Canada, right. Election of Rajya Sabha members, that is not right. Not Ireland, that is South Africa. And concurrent list is Australia is correct. Advisory jurisdiction is provided under Article 143, that is exclusive jurisdiction of the Supreme Court, under which the President can seek advice of the Supreme Court on various issues, and independent judiciary is provided under various provisions. So that is borrowed from USA. And concurrent list is a common list between central and states. It's correct, but election of Rajya Sabha members, which is provided under Article 80, are not borrowed from, is not borrowed from Ireland, but rather from South Africa. So answer will be C. Okay. Then we'll come to question number 12. 2020. The emergency provision is derived from, emergency is provided completely from Government of India Act 1930. B. Which is not a cause to declare national emergency. Which is not a cause. National emergency is declared by promulgated by President on the written advice of the Cabinet on the three grounds: war, armed rebellion, external aggression. So internal disturbance C is the answer. But here let me inform you or provide you some necessary information that internal disturbance was originally a condition or a cause, but in 1978 by 44th Constitutional Amendment Act, the Moraji Desai government replaced the term internal disturbance with armed rebellion because internal disturbance was quite subjective in nature and there was no clear cut definition what constitutes internal disturbance. Therefore, the 1975 emergency was imposed on certain grounds which brought under internal disturbance. So that was not clear whether those reasons should be brought. Therefore, it is replaced with armed rebellion. Question number 21, answer will be C. Then 22. Which among the following is not a feature of Soviet constitutions? We have borrowed justice, 5-year planning, fundamental duties, and we will borrow the joint sitting. Joint sitting is borrowed from the Australian constitution. So answer will be D. Okay, joint sitting is from Australian constitution that is provided under Article 108 of the constitution. Next, 23, Weimar Constitution of Germany gives us Weimar Constitution, that is German Constitution, which was drafted in 1949. We have borrowed only the provision of suspension of fundamental rights during national emergency. National emergency is imposed on war and external aggression and armed rebellion. But remember, when national emergency is promulgated by the president on the written advice of the cabinet on these two grounds, war and external aggression, then Article 19 is automatically suspended. Automatically suspended. Article 19 is automatically suspended. And this automatic suspension of Article 19 is provided under Article 358. Got it? But the president can notify for the suspension of other fundamental rights through notification. That is 359. So 19 is automatic. That is, these are the provisions we have borrowed from the German constitution. The German constitution. So answer will be D. When was the national anthem adopted by the constitution? It was on 24th January 1950. On this day, along with national anthem, national song was also adopted. And Rajendra Prasad got unanimously elected as the first president of India. And 24th January was the last working day of the Constituent Assembly. That is also a point to be noted. So that will be C. Question number 25. Which of the following parts constitute the philosophical part? What do you mean by philosophical part of the Constitution? What idea? What constitutes philosophical part? Philosophy means the ideals, the goals, the objectives, the targets of the Constitution. The objectives of the Constitution is social justice, equality, liberty, and also fraternity. Justice, equality, liberty, and fraternity. but justice, equality, and liberty are mostly ensured by Part 3 and Part 4. So, Part 3 also contributes political justice, political equality, political freedom, and also it grants related to social justice part. And DPSP is about socio-economic democracy. So, Part 3 and Part 4B. Which among the following is a feature of parliamentary form of government? I told you parliamentary parliamentary foremost characteristic is close relationship between the executive and legislature. In a presidential system, the executive stands separate from legislature. Executive is separate, but in parliamentary system, the executive are member of the parliament. They are accountable to parliament for their acts of omission and commissions. So, will be answer is executive is responsible. Executive is responsible to legislature, that is under Article 75, Clause 3. So that is a central, the pivotal principle of parliamentary democracy. Okay, that is B. 26 answer is B. Okay. Now, dear ones, now come to the 27. 27 says which of the following is a feature common both to Indian Federation and USA Federation. Again, the question comes, which is common. So, single citizenship is not common because USA has dual citizenship. USA has dual citizenship, so it is incorrect. Three list of the constitution is not there. Cabinet form of the government is not there. Federal Supreme Court is there. So, answer will be D. So, in America, there is no list provided. Only certain powers, certain subjects are given to the center, and the rest power, including the residuary powers of lawmaking, are granted to the state. So they have a strong states, weak center. But the reverse is true with respect to the Indian political system. We have a strong center and weak states. So there are no similarities in that regard. Only federal Supreme Court is there. So they have federal Supreme Court. We have also federal Supreme Court. And why it is federal? Because they resolve the disputes, federal disputes. Federal disputes means disputes between central and states, and also disputes between the states or among the states. Okay, 27. 28. Which of the following part was added to the Constitution through an amendment in 1970s? All the parts have been added by an amendment. Look at the number of amendments that I am writing. That is, part IBA is added by part IBA is added by 42nd Amendment Act. 42nd Amendment Act 1976, and your part IX is by 73rd Amendment Act 1992. Part IX is added by 74th Amendment Act 1992, and part 9B is added by 97 Constitutional Amendment Act 2011. So that is a point also. So please take a note of that. So answer will be A. Answer will be A. The pen is not working. Kindly take a note of this. The pen is not working, so I'm just telling you the answer. Telling you the answer. Okay. Look at question number 29. Universal franchise is allowed under Article 326. That is correct. And limited franchise was allowed under Article Government of India. That is correct. So answer will be C. Both B and 1 and 2. So answer will be C. Okay. Question number 30. Which of the following is an extra constitutional? First of all, you have to get an idea about what extra constitutional bodies. They are called extra constitutional because they are not mentioned in the constitution. They do not derive their strength and powers from the constitution. Rather, they are established under an act or even under the order of the executive. So, extra constitutional may be a statutory or executive body. And when you divide statutory body, there are a number of bodies comes under statutory bodies like regulatory bodies, quasi-judicial bodies, autonomous bodies, advisory bodies. So that is the fundamental things. Here, except Lokpal of India, all of them are constitutional bodies. So it is the only extra constitutional body. So answer will be D. Which of the following language is not there in the 8th schedule of the Constitution of India? Rajasthan is a language which is not mentioned in the 8th schedule so far. Only 22 languages have been included. The Bodo Dogri was added by 92nd Constitutional Amendment Act. 92nd Constitutional Amendment Act. And Sindhi was added by 21st Constitutional Amendment Act 1967. And Nepali was added by 71st Constitutional Amendment Act, your 1992. So there have been three amendments. There have been three amendments enacted to add that. Okay, got it? That is 92nd Amendment Act 2003. Okay. So we'll continue the class. The pen is not working properly. So I'm showing you the sign through mouse arrow. Now we'll come to 32. Which are of the following constitutional amendment is related to 8-7? Is related to. Okay, it will be better to say which is not related. The question may be like this, not related. Because all the amendments that I have told you is there, except one. So 21st is there, 71st is there, 92nd is there. That means that will be the wrong answer. So answer will be C. Okay. So answer will be C. Answer will be C. Who called Indian federalism as cooperative federalism? Who called Indian federalism as cooperative federalism? That will be Granville Austin. Granville Austin described Indian federalism is cooperative federalism because here the cooperation between the central and state is essential factor for the successful functioning of for the successful functioning of the Indian Federation. And Maurice Jones, one of the noted constitutional law authority, said that Indian constitution is an example of bargaining federalism. Sorry, Asiana. So pen is working now. So remember, Granville Austin says cooperative federalism. And Maurice Jones describes India as bargaining federalism. And Ivor Jennings say it's federalism with centralizing tendency. Sir Ivor Jennings. So these three quotations are important. And it is called bargaining federalism because in bargaining federalism, the federating units uh, that is because in bargaining federalism, the federating units have a chance to bargain with the center for more assistance and more support to their states because uh, after the advent of regional parties at the center, the concept of the principle of bargaining federalism emerged. Okay, that is why, and Ivor Jennings has rightly said that it is a federalism with centralizing tendency. So answer according to our perception will be A. Okay, answer will be A. Next, your question number 34. English crown is an example of nominal executive like the President of India. But the difference is there between English crown and president because English crown is hereditary in nature and your president is elected in nature. But their official position is same in both countries. Both of them are nominal and both of them are ceremonial heads. They have little power in the governance. Okay. 35. The presidential government operates on the principle of presidential government that are prevalent in America mostly are division of powers no, centralization power no, balance of powers no, separation of strict separation of. In presidential system there is strict separation of. In parliamentary system, there is no strict separation. The powers are not concentrated in one hand in parliamentary system, but the executive and the legislature are not separate closely. Visibly, they are close to each other. Although they have respective areas to play, but they are close. So the way in Indian system there is no strict separation of power. But remember, separation of power is there. Separation of power is not absent in India. Rather, it is present, but it is not to the extent that is present in the USA in the presidential system. Okay, that is so. Therefore, answer is D. Answer is D. Separation of power. Doctrine of separation of power. Doctrine of separation of power was propounded by whom? Separation of power was propounded by your Montesquieu. That is Montesquieu. Look at the spelling of the word Montesquieu. 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 So Montesquieu, Montesquieu, the French political philosopher Charles Montesquieu, first proposed the theory of separation of powers in his book The Spirit of Laws in 18th century. Okay, that is Charles Montesquieu. In his book The Spirit of Laws, The Spirit of Laws, okay, now we'll come to 36. Who said Indian Constitution is an example of bargaining federal that we have already discussed? Maurice Jones. Okay, who among the following said, gave the following statement that Indian Constitution strikes a good balance between the rigidity and flexibility. So strikes a balance between flexibility and rigidity. Okay, that is also said by Casey. That is Casey Hoyer and also Alexander. So based on extreme rigidities of the ପାଇଁ এটা Alexander but Casey Hoyer भी କହିଥିଲେ कि it strikes a good balance between rigidity and flexibility ବି କହିଥିଲେ. Extreme rigidity শব্দটা সেটা Alexandroic mentioned it. Okay, that is 37. Answer is C. But I repeat the thing that Casey has also mentioned that Indian Constitution is an example of rigidity and flexibility. The 38. Basic features of Indian Constitution which are not amendable under Article 368 are. See, all the provisions are basic features which cannot be destroyed by the basic features. So all the provisions, I think, are basic features. Sovereignty, sovereignty, and your what? Sovereignty and territorial integrity, federal system, judicial review, parliamentary system of government. So all the concepts are correct. So option D will be the best answer. Option D will be the best answer. Then question number 39. Question number 39. The basic features which are not amendable, the same question is repeated. So answer will be D. 40. Democracy in India rests on the fact that. What will be the answer? Democracy. Democracy in India rests on the fact that means which is the basic principle or basic requirement of democracy in India. Their constitution is written on. That doesn't mean that written unwritten constitution cannot be there. UK is an example where there is unwritten constitution, but it is a democracy. So that is not the fundamental requirement. And there are fundamental rights. Obviously, in a democracy, individual rights are quite essential. But the most essential thing is C. People have rights to choose and change them. That is called demos and kratos. Be government by people. So the core principle of democracy in India is that people have the right to choose, not only in India, but in most all democracies. They have a right, people have a right to choose and change them. Because if we look at other forms of government, say autocracy, oligarchy, aristocracy, monarchy, plutocracy, there are other forms of government where democracy, where people did not have the power to change the government, to choose the government. The state or the authority or the government was self-appointed on the basis of their power and influence. There was fighting, struggles, battles, fought for being the ruler or being the government. But in democracy, there is a fight, but fight between the candidates in front before the people of the country. They will choose one of them. They will choose one of them as the best party or the best ruler of the country. Therefore, in a democracy, the fundamental things is the choice of the people, is the rights of the people. Therefore, it is called demos and kratos. Demos and kratos. That is the things. Okay. So today we have discussed very standard questions on salient features. It's not very tough questions, but for clearance of your basics, I have provided these questions. In the next class, I'll be bringing some tough questions based on previous year papers. These are also included in certain previous year papers in various examinations. But we'll also discuss some advanced questions that appear in the EPSC examinations and OPSC exam too. Okay. So I think this discussion is being very helpful to all of you. Kindly kindly like and give your constructive comments and also share it as much as possible if you consider it a useful class by Vanik IS. Okay, wish you all the best and wish you a good career ahead. Vanik will be along with you in your until you achieve your success in your long journey. We are taking efforts in different ways to be closer to you and to help you realize your dream. I think and I hope that these efforts of Vanik will be really praised by you and you will like it, share it in greater number and join Vanik possible. Okay? Thank you very much for being with me in this class.